Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: Key differences between California and federal employment laws. California's employment laws embody a distinctive and comprehensive framework, often more protective of employees than federal regulations. This divergence stems from California's legislative intent to safeguard workers' rights extensively, thereby establishing a complex landscape that human resources professionals must navigate to achieve PHRca certification. Understanding these key differences is crucial for HR practitioners aiming to ensure compliance and foster equitable workplace environments. California's stance on at-will employment is notably more restrictive compared to federal law. While the United States follows the at-will employment doctrine, allowing employers to terminate employees without cause, California imposes several limitations. Under California law, at-will employment can be overridden by implied contracts, public policy exceptions, and statutory protections. For instance, employees cannot be terminated for reasons that violate public policy, such as refusing to engage in illegal activities or reporting workplace safety violations. Additionally, implied contracts created through employer conduct or verbal assurances can restrict an employer's ability to terminate without cause. This nuanced approach underscores the necessity for HR professionals to meticulously document employment agreements and practices to mitigate potential legal disputes. Wage and hour laws in California exemplify another significant departure from federal standards. The Fair Labor Standards Act sets the baseline for minimum wage and overtime pay. However, California's regulations are more stringent. As of 2023, California's minimum wage is $15.50 per hour for all employers, exceeding the federal minimum wage of $7.25 per hour. Moreover, California mandates daily overtime pay for hours worked over 8 in a day and double time for hours worked over 12, contrasting with the FLSA's weekly overtime threshold of 40 hours. The state's regulations also encompass specific provisions for meal and rest breaks, requiring a 30-minute meal break for every 5 hours worked and a 10-minute rest break for every 4 hours, a stipulation not mandated by federal law. Non-compliance with these requirements can lead to substantial penalties, emphasizing the importance of vigilant timekeeping and payroll practices. Discrimination and harassment protections under California law are broader than federal statutes, providing employees with augmented safeguards. The Fair Employment and Housing Act offers more extensive coverage compared to Title VII of the Civil Rights Act of 1964. PHRca applies to employers with 5 or more employees, whereas Title VII covers employers with 15 or more employees. This lower threshold ensures that smaller businesses in California are held to anti-discrimination standards. Additionally, FEA includes more protected categories, such as gender identity, gender expression, sexual orientation, and marital status, which are not explicitly covered under federal law. The state's robust stance on workplace harassment is evident in its requirement for employers with 5 or more employees to provide sexual harassment prevention training, thereby fostering a safer and more inclusive work environment. Family and medical leave regulations in California also reflect a more employee-centric approach compared to federal law. The Federal Family and Medical Leave Act allows eligible employees to take up to 12 weeks of unpaid leave for specified family and medical reasons. In contrast, the California Family Rights Act expands on FMLA provisions by including domestic partners as eligible family members for leave purposes and offering leave for a broader range of reasons, including the serious health condition of a child of a domestic partner. Furthermore, California's pregnancy disability leave provides up to 4 months of leave for pregnancy-related conditions, which can be taken in addition to PHRca leave. These expansive provisions necessitate that HR professionals manage leave policies with precision to ensure compliance and support employee well-being. Worker classification is another critical area where California law diverges from federal standards. The federal standard for determining employee versus independent contractor status relies on the economic realities test, which considers factors such as the degree of control exerted by the employer and the worker's opportunity for profit or loss. However, California's Assembly Bill 5 introduced the ABC test, a more stringent criterion for classifying workers. Under the ABC test, a worker is presumed to be an employee unless the employer can demonstrate that the worker is free from control, performs work outside the usual course of the hiring entity's business, and is customarily engaged in an independently established trade or occupation. This presumption of employee status aims to prevent misclassification and ensure that workers receive the benefits and protections they are entitled to, such as minimum wage and overtime pay. HR professionals must carefully evaluate worker roles and contractual agreements to navigate the complexities of classification under AB 5. California's approach to employee privacy rights also sets it apart from federal regulations. While the federal Constitution provides limited privacy protections, California's Constitution explicitly guarantees the right to privacy. This extends to workplace privacy, where employees have a reasonable expectation of privacy in areas such as personal belongings and electronic communications. Additionally, the California Consumer Privacy Act grants employees the right to know what personal information is collected about them and how it is used, thereby imposing stringent data protection and transparency requirements on employers. The CCPA's application to employee data underscores the necessity for HR professionals to implement comprehensive data privacy policies and practices to safeguard sensitive information and uphold employee trust. California's stringent policies on workplace safety further exemplify its proactive stance in protecting employees. The Occupational Safety and Health Act sets federal standards for workplace safety, but California operates its own state plan, Cal-OSHA, which often imposes more rigorous requirements. For example, Cal-OSHA's Injury and Illness Prevention Program mandates that employers develop, implement, and maintain an effective program to identify and address workplace hazards, a requirement not specified under federal OSHA standards. Compliance with Cal-OSHA regulations necessitates that HR professionals stay abreast of evolving safety standards and ensure that workplace safety programs are robust and comprehensive. In conclusion, the key differences between California and federal employment laws underscore the state's commitment to providing extensive protections for employees. From limitations on at-will employment and stringent wage and hour laws to broad anti-discrimination protections and expansive family leave provisions, California's regulatory landscape demands meticulous attention from HR professionals. Worker classification, employee privacy rights, and workplace safety standards further illustrate the unique challenges and responsibilities faced by those seeking PHRca certification. By understanding and navigating these complexities, HR practitioners can ensure compliance, foster equitable workplaces, and uphold the highest standards of employee welfare. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.